Hello and welcome to our Facebook Live event. I'm Reem Sobey. I'm an attorney at Abel's Toledo office. Today is the 8th of May, and this is our first live video on tenants' rights. Advocates for Basic Legal Equality, or ABLE, is a nonprofit law firm that provides free legal assistance in civil matters to eligible individuals and families in Western Ohio. Before I get started, I want to go over a few points about this video. You may need help from an attorney. If you live in Able's service area, you can apply for legal assistance by calling our legal aid line at 888-534-1432. Or you can apply online by clicking the link in the comments. You will find a link with a map highlighting Able's service area in the comments section. As I'm talking, you can also post questions you have in the comments box. I will try to answer as many questions as I can with general information. I will provide general legal information about tenants' rights in Ohio only. I'm not providing you with legal advice, and you should be aware that information regarding new laws, policies, and interpretation continues to change. You can call us to apply for legal assistance after the video. We will have attorneys available to talk to you about your specific situation from 3 p.m. until 5 p.m. Just call our legal aid line at 888-534-1432. Let them know that you're calling from the Facebook Live video. You can also call us after that time, anytime, to apply for legal assistance. Now let's get started. The information I'll be providing in this video is current as of today, May 8th. I will provide an overview of the general issues surrounding current housing needs and concerns during the COVID-19 pandemic. Ohio and the United States as a whole is experiencing a pandemic, and during this time, many people cannot afford to pay rent. Some states have passed eviction moratoriums or holds on evictions. Ohio does not currently have a uniform statewide hold on evictions, but most courts in Ohio are not hearing eviction cases right now. Some courts are allowing eviction filings, but scheduling the hearings after a certain date, like May 30th or June 5th, or some other date. Other courts in Ohio are not allowing eviction filings at all until a certain later date, while a few courts are allowing both filings and hearings to continue during the pandemic. Regardless of what your court is doing, as always, tenants remain responsible to pay rent each month. If you live in our service area, you can click the link below to find out whether your court is hearing evictions. The link will show you a map of all courts in Able's service area with information on whether they're hearing eviction cases right now. Now, information continues to change rapidly. So while we are regularly updating this map, information for your court may have changed since our last update. I strongly recommend that you visit your court's website for the most recent information. Now, even though Ohio doesn't have a statewide moratorium, there is a federal nationwide hold on evictions for some specific types of housing, pursuant to the Federal CARES Act that Congress passed. The CARES Act applies to the following types of housing: public housing and other federally subsidized housing, like Section 8 project-based housing, and Section 8 vouchers, as well as housing that received or receives a low-income housing tax credit, or LIHTC housing. The CARES Act also applies to housing that receives USDA rental housing assistance including the Rural Housing Voucher Program, as well as housing that has a federally backed loan from the FHA, VA, USDA, Fannie Mae, or Freddie Mac. We will post a link in the comments box to a list of those types of housing so that you can check if you are protected. Now, if you live in any of the types of housing covered by the CARES Act, your landlord is not allowed to file a new eviction for non-payment of rent or charge you fees, penalties, or other charges related to non-payment of rent until after July 25th, 2020. This doesn't mean that you're not responsible for rent. You are still responsible for paying rent. So why does it matter if you're protected by the CARES Act or if your court is not hearing eviction cases right now? Well, it matters because it means that you cannot be removed from your home during those protective periods. A court process is the only legal way to remove a tenant from a home in Ohio. It is not enough for your landlord to file an eviction case in court. After they file, they still cannot remove you until there's an eviction hearing and the court issues an order. Even then, your landlord cannot simply decide to lock you out. They have to wait for you to leave or for an official to remove you. If your landlord takes it upon themselves to shut off your utilities, change your locks, or remove your belongings, they would be engaging in an illegal lockout, and they can be penalized by a court. Only a deputy sheriff or court bailiff is allowed to remove you from your home, and they can only do that pursuant to a court order. So how do they get such a court order? And what is an eviction? An eviction is a legal process where a property owner gains possession of a rental unit by asking a court to remove the tenant from that property. Once an eviction is filed by a landlord, a court moves to schedule a hearing to give each side an opportunity to make their case. At that point, if the court decides that the tenant should be removed from the property, the court can issue an order giving the tenant a specific amount of time to leave the property. If the tenant doesn't leave, the sheriff or bailiff can remove them from the property. Now, while most courts in Ohio aren't hearing eviction cases right now, depending on the court, a landlord may be able to file an eviction complaint during COVID-19, but have to wait for the hearing to take place later when the court is reopened for eviction hearings. So the question becomes, when your court starts hearing eviction cases again, or if you're protected by the CARES Act, when that protection ends, what will happen and what can you do? Unfortunately, once your local court resumes eviction hearings, if you had failed to pay rent on time, you can be evicted. Because failure to pay rent when it is due as noted in a rental agreement is a violation of that rental agreement. When a tenant violates a rental or lease agreement, Ohio law states that their landlord can file an eviction case in court to remove that tenant from the home. That is true even if you offer your landlord the full amount of overdue rent later, because the law does not require your landlord to accept late rent. Now again, as we discussed earlier, if you live in housing protected by the CARES Act, your landlord has to wait until after July 25th of this year before they can proceed to evict you. If your housing is not covered by the CARES Act, your landlord does not have to wait until July 25th. They only have to wait until their and your court reopens for eviction hearings. I know that many people have lost jobs and money due to COVID-19. And people are asking, can I stop paying rent if I lost my job due to the COVID-19 pandemic? The answer is no. Failure to pay rent when it is due as noted in a rental agreement is a violation of that rental agreement. When a tenant violates a rental agreement or lease in Ohio, their landlord can file an eviction case in court to remove that tenant from the home. Several community groups and elected officials and us at ABLE are advocating for programs to help Ohio renters during this pandemic and the aftermath of the pandemic, such as rental assistance programs and pay-to-stay legislation. Rental assistance programs provide money to Ohioans struggling to pay rent to protect them from displacement and prevent homelessness. We have seen these programs use money from the CARES Act and other sources of funding. You can call United Way 211 or your city or county offices or your local homelessness board to inquire about the existence of such a program in your city or county. In the Dayton area, you can also call the Community Action Partnership at 937-341-5000, as they may have rental assistance funds available. You can also ask that your city, county, local homelessness board, or community group take leadership on creating and administering a rental assistance program. One of the other ways to protect renters during this crisis is passing pay-to-stay laws. Pay-to-stay legislation would require a landlord to accept late rent. Right now, no such legislation exists statewide or in any cities in ABLE's service area. This means that your landlord can evict you once courts reopen, or if you're protected by the CARES Act after July 25th, even if you offer to pay late rent and pay any fees at that point. The fact that your court is not hearing eviction cases right now does not mean that you cannot be evicted ever. It just means that you cannot be evicted while your court is closed to eviction hearings. This is why tenants should pay rent on time if they can. Whether your local court is hearing eviction cases or not, we strongly recommend that if you cannot pay rent on time, you should communicate with your landlord about your situation by telling them in writing that you cannot pay rent, telling them why, and explaining whether you will have money available to you coming soon that you can use to pay rent with, such as unemployment compensation. We have a sample letter or text for you to use when communicating with your landlord. That sample will be posted along with this video. You should also know that the Ohio Department of Health Director has issued a list of recommendations to landlords in Ohio, asking them to not evict tenants who cannot pay rent during the pandemic. The recommendation will be linked below the video. And while it's only a recommendation, not an order, it can still be helpful to use when talking to your landlord. Dr. Amy Acton recommends that landlords be open to discussing alternative payment arrangements, such as rent reduction, payment deferrals, repayment plans, waiving late fees, or other means of assistance. I would also recommend that if you need rent assistance, you call United Way's 211 helpline to be connected to any resources. If you can't pay rent and want to work out an agreement with your landlord, the optimal situation is where your landlord agrees to cancel rent during the pandemic, or agrees to reduce rent, or to accept late rent without any penalties, and to not evict you. But in some cases, the landlord may not agree, and might tell you that even if they cannot evict you now, they plan to evict you once courts start hearing eviction cases again. In Ohio, a landlord may bring an eviction action against a tenant when the tenant has done any of the following: failed to pay rent on time, failed to follow the terms of the lease agreement, failed to follow their duties under state law, or occupied the unit after termination or expiration of the rental agreement. This situation of Ohio law has left many people extremely frustrated by the lack of sufficient protections for tenants. But something that Ohio law provides is a protection for tenants who want to organize. Ohio landlord-tenant law protects you when you organize with other tenants and form a tenants union with other tenants to ask your landlord to promise to accept rent after the pandemic is over. In Ohio, a landlord is prohibited from retaliating against a tenant because the tenant asserted their rights or organized with other tenants. So if you complain to a public official, complain to your landlord, or organize a group of tenants, or form a tenants union to negotiate or deal collectively with your landlord about any of the terms and conditions of the rental agreement, your landlord cannot respond by retaliating against you. Retaliation can come in many forms, such as increasing rent, terminating or failing to renew a rental agreement, evicting or threatening to evict a tenant, or decreasing services. Excuse me. An example of decreasing services is if your landlord used to pick up trash every week and then stops doing that. If your landlord does any of those things because you complained to a public official or organized a group of tenants to form a tenants union, to negotiate or deal collectively, or complained to the landlord, you can assert your rights and tell your landlord and the court that your landlord is violating the Ohio Revised Code. I'll say this one more time. Ohio law protects you when you want to organize by prohibiting your landlord from retaliating against you because you organized to negotiate or deal collectively about any of the terms and conditions of the rental agreement. If you believe your landlord is retaliating against you, you should talk to an attorney. I'm going to stop now and take some questions. I know that was a lot of information. You are welcome to call us if you have any questions about anything I said, or if you need help negotiating with your landlord, or if you're served with eviction papers, or if you have any other legal questions. We have attorneys ready to talk to you today from 3 to 5 p.m. if you're calling after this video. You can also call us anytime to apply for our services on any other day. You can type your general questions in the comments box. I'm going to talk about a few questions that we received before the video, and I'll continue watching the comments box for questions. A lot of people have asked us about displaying signs. Many lease agreements in Ohio contain terms prohibiting the display of signs. So if you do that in violation of your lease agreement, your landlord will argue that you should be evicted for violating the lease. You're in a much better position if your lease agreement does not prohibit the display of signs. If your lease agreement does not prohibit the display of signs, and you display signs such as reduced rent or tenant group or rent strike, and your landlord takes negative action against you, that is likely to be illegal retaliation by your landlord. Why? Because Ohio law prohibits a landlord from retaliating against a tenant for doing something together with other tenants to negotiate or deal collectively with the landlord about the lease terms. Again, that protection only exists when your actions are not themselves a violation of your lease agreement or a violation of your duties as a tenant. Other people have asked us what they can do if their landlord tries to lock them out of the home. Under Ohio law, the only way to evict a tenant is through the court system. It is illegal for a landlord to do any of the following to remove a tenant from their property: physically forcing the tenant out of the property, threatening to hurt the tenant if the tenant doesn't leave, removing the tenant's belongings without permission, turning off utilities such as gas, electric, and water, changing the locks, or altering the property to make it unlivable. If a landlord engages in any of these activities, you can consider calling the police or filing a complaint in court. The court may award you damages and attorney's fees. I'm going to check for some questions. I'm reading a question. I'm going to read two more questions and answers that we have, and then I'll get into the questions in the comments box. Some people have asked us about their rights to have guests over as tenants. A landlord does not have the right to infringe on a tenant's right to have guests unless health authorities have issued specific orders that prohibit guests. A tenant's right to have guests comes from their right to possess and control the premises, usually based in the lease, and under the legal concept of the covenant of quiet enjoyment. In Ohio, this right is implied in every rental lease agreement. The right of a tenant to have guests in their rental unit is violated when a landlord obstructs, interferes with, or takes away from the tenant the ability to have guests and invite guests over. The right to have guests includes the right to use the common area for travel to and from the rental unit. There is nothing in Ohio's stay-at-home orders that gives a landlord the power to infringe on the right of a tenant to have guests. So let's go back to rent. What should you do if you cannot pay rent? If you can, you should pay your rent and continue to do so. But if you cannot, or you cannot pay the full amount of rent, you should communicate with your landlord in writing, preferably email, so that you have a copy of that email, and explain your situation. Offer to pay rent in whatever amount you can and ask your landlord to work with you. You can use the sample letter or text that we posted in the comments box. Remember, if you live in one of the highlighted counties in our service area, you may apply for help by calling our legal aid line at 888-534-1432. Or you may apply online at www.legalaidline.org by clicking the link in the comments. If you don't live in one of our service areas, but you live in Ohio, you can find your local legal aid organization at www.ohiolegalhelp.org. Now I'm going to go back to check comments for questions. I'm not seeing additional questions at this time, so I'm going to wish you all a lovely weekend. Please remember to share this post. As I said, you can call us between 3 and 5 today to speak to one of our attorneys, or you can call us anytime to apply for legal assistance. Have a lovely weekend, and thanks for tuning in.